I want to thank you for attending. My name is Julia O'Connor. I'm a manager at Quad-L. Since 1987, I have administered several housing choice voucher programs, including project-based and tenant-based, MTW, HOPWA, FSS, Welfare to Work. I've been hired by several housing authorities to act as their hearing officer. I just want to take a second and talk about Quad-L. We've been around for more than 38 years, and we've been a trusted partner with public housing authorities, providing technical assistance and program support services and training. We've been a leader in designing and operating programs that provide high quality and effective housing choice voucher program mobility counseling services. Our success is a direct result of our understanding of what the regulations require and the experience of our staff. We have participated and witnessed the evolution of strategies and services in the housing industry and have an understanding of what works and what doesn't in the ever-changing affordable fair housing climate. So thank you. I'm not going to talk anymore about us. Let's get on to what you're really here for, and that is the terminations and hearings. First, let's talk about what is the purpose of the PHA. Of course, it's to provide housing. We're there to house families. We're there to run a credible program, be fair. PHAs are allowed to deny or terminate assistance, and sometimes the enforcers become a little too focused on denial and termination and not providing housing assistance. So what do we need to do while we're maintaining program integrity? It's important that the programs operate as efficiently as possible, utilization is maintained, and that HAP is paid accurately. HUD gives us the guidelines on how to keep the integrity of the program. PHAs have several tools to use. You have 24 CFR 982-552 through 555. You have your admin plan. You have PIH notices which are published, and documents that you provide the tenants, such as the voucher, the HUD tenancy addendum, and briefing packet. So let's discuss what the regulations are really saying. There are permissive, discretionary, and mandatory grounds for denial and terminations. When a PHA is allowed to use their discretion on how to handle a situation, the regulations use words such as may, will, however, to give the latitude in the decisions. The PHA must identify how they will handle these scenarios in their admin plan. When the regulations state must, then the PHA needs to create standards for the exceptions when they are permitted to. The PHA must identify how they will handle these scenarios in their admin plan. Hear that key word, admin plan? So let's talk about permissive grounds. An action or an inaction by a family. When reviewing the regulations, they actually state the PHA may act. May includes any or all of the following: denying listing on the PHA waiting list. When would you deny? Possibly for not completing the application entirely. What about not entering into a contract? A PHA could say they will not enter into a contract for less than 12 months and the owner only wants 6 months. Remember, this could be a financial burden on a family if they have to move in less than 12 months, and an administrative burden on the PHA for having to process paperwork again in less than 12 months. Think about the different reasons why you could possibly deny any of these items. And again, how you handle these situations must be in your admin plan. When looking at discretionary grounds for denial or termination, HUD gives the PHA control when they say they have the authority. If a family violates a family obligation, the PHA should ask questions about the situation, such as, who in the family violated the obligation, and was there an extenuating circumstance that caused the violation? What does your admin plan say about overnight guests? How many days is considered living in the unit? What is considered prompt notice if somebody moves out? Tenant-caused HQS failures. Do damages include utility shutoff? When saying if any member of a household, this means not just the head of house has to be in that scenario. It's anyone in there. What could be a reason we would deny assistance for an eviction? The PHA should ask questions about the situation, such as maybe the eviction was due to a family member that's no longer a part of the household. When looking at current debt to the PHA, think about reasons a person could owe money to the PHA. Could there be a repayment agreement which would override the denial or termination? Has the family reimbursed the PHA? Do they have or did they breach a repayment agreement? The PHA, at its discretion, may offer a family the opportunity to enter an agreement to pay amounts owed to the PHA or to repay any amounts paid by the PHA to an owner. Remember, the PHA prescribes the terms of the agreement. Then let's talk about threatened abuse toward housing office personnel. How many times have you had to deal with an irate client? We all know that we don't always want to tell a family what they want to hear, and sometimes they take their aggression out on staff. PHAs must decide in which situation they terminate and which situations they tolerate. Criminal activity. Did the family member serve time and are now out of jail? If the PHA has an FSS program, what could happen if the family doesn't comply with the FSS contract or the Welfare to Work program? You need to look at the obligations under the program and decide what is termination worthy. Again, the PHA has the discretion to act on all of these scenarios. When using the discretion, the PHA needs to look at circumstances. What was the extent of the individual family member's participation? Were there mitigating circumstances related to disability? What about family members not involved? How will they be affected? In deciding whether to exercise their discretion to admit or to retain an individual or household that is engaged in criminal activity, PHAs and owners must consider all of the circumstances relevant to the decision. And that's including but not limited to the seriousness of the offense, the effect that the eviction of the entire household would have on a family members that were not involved in that criminal activity, the extent to which a leaseholder has taken all reasonable steps to prevent or mitigate criminal activity. If a family member involved was no longer a part of the household, would the family still be in compliance? For example, the circumstances leading to an eviction no longer exist because the household member that caused it has died or they're incarcerated. The PHA may permit other family members to continue with their assistance. You also could look at addiction, look at rehab. Is there evidence of rehab? Because addiction could be a disability. When considering whether to deny the admission or termination of assistance or tenancy for illegal drug use by a household member who is no longer doing that activity, a PHA or owner may consider whether the household member participating in that rehabilitation has completely successfully completed a drug rehab program or has been rehabilitated successfully. Does a family include a person with disabilities? If so, there needs to be consideration of a reasonable accommodation. And you can't forget fair housing and equal opportunity and the protection of victims of domestic violence, and dating violence, and stalking. When you're considering the situations, you always want to look at the seriousness of the offending action, especially with the respect of how it would have effect on other residents. The extent of participation of the leaseholder or household members in the offending action, including whether the culpable member is a minor, a person with disabilities, or a victim of domestic violence. The effect on the community of the termination, the effect of the PHA's decision on the integrity of the program, the demand for housing by eligible families who are adhering to their lease requirements, the extent to which a leaseholder has shown personal responsibility, and whether they've taken all reasonable steps to prevent or mitigate offending actions. What about the length of time since the violation occurred? The family's recent history and the likelihood of a favorable conduct in the future. These are mandatory denial reasons, but there could be discretion for drug and criminals, such as successfully completing that supervised training, drug rehab training. Remember earlier I stated with the mandatory grounds, HUD tells you when you need to establish standards to address the exception. This list shows where the regulations state the PHA must establish standards to terminate assistance if the PHA determines that any household member is engaged in illegal use of drug, or a pattern of illegal use of drug by any household member interferes with the health, safety, or right to peaceful enjoyment of the premises by other residents. This list includes criminal activity and alcohol abuse. Does your admin plan state the timeframes for when these items occurred? What about successful completion of rehab? All of these items could have exceptions, and the PHA admin plan needs to address what happens with the exceptions. Then we have termination grounds where HUD does not really give the PHA direction on establishing standards for an exception. Remember, the regulations tell the PHA when they must do something and if they have discretion to make an exception. Conviction of manufacturing of methamphetamine in a Section 8 unit cannot be ignored. If a person refuses to sign their 9886 form, then the PHA can't complete the verifications. If you don't know if someone's a citizen, you don't know if you can pay, if you are paying the correct HAP amount. So now that we've gone through reasons why you can deny and terminate, are you ready? What documentation do you need to make sure your denial or termination will hold up against the challenges? Let's look at what's good. You have file documents. What in a file can be used as evidence? What did the participant actually claim versus what third party or public records document? Who has the first-hand knowledge of what has occurred? These are all good items that you can rely on. But what about the not so good, the bad items? If you can't verify an item, then how are you going to prove it? I've heard a lot of complaining about participants through the years, but without something to support the allegations, we have not been able to act on terminating. And everyone knows that assumptions are not factual. Just because a participant is driving that luxury car doesn't mean they own it. Or what about coming to the office dressed in designer clothes? We know staff talk about this, and I have to remind staff on a regular basis, designer clothes can be purchased at secondhand stores. So without evidence of the bad behavior, a PHA can't act. Let's take a minute and talk about those great photos. Before we move on to preponderance of evidence, I want to make sure that you understand that when you are presenting photos, you want to have a photo log for an informal hearing officer. And that photo log needs to include the 5 W's: who, what, where, when, and why. You want to make sure that you print important photos in color. Black and white photos don't always show what the hearing officer needs to see. And I've attended several hearings where photos were in black and white and the hearing officer couldn't tell what the PHA was trying to show as evidence. The hearing officer must rely on what is presented, and if it isn't there, then it didn't happen. So now let's go to preponderance of the evidence. What is good and bad for terminating when looking at the preponderance of evidence? When the PHA is using the preponderance of evidence, their burden of proof required is to convince the hearing officer that a given proposition is true, that it is more than 50% believable. The best forms of evidence are listed here: file documents, application forms, third-party verification, EIV. Remember, a PHA's job is to convince the hearing officer that the bad behavior occurred. Now we have discussed what a PHA needs to prove, but HUD threw the curveball with PIH 2015-19. HUD clarified that an arrest is not preponderance of evidence, but it's a suspicion that a household member or guest has engaged in criminal activity. Before A PHA or owner can deny admission or terminate assistance. They must determine that there is sufficient evidence that the individual engaged in such activity. An arrest record shows that somebody was probably suspected of the activity, but in many cases, and we all know it, arrests do not result in criminal charges, and even where they do, the charges are often dismissed or the person is not convicted of the alleged crime. So what can we do? What can a PHA do with an arrest? Well, it could trigger an inquiry into if there's sufficient evidence to terminate or deny. It could trigger the use of other evidence, such as police reports detailing the circumstances of arrest, witness statements, other relevant documentation, and eventual conviction. Just remember, your policies must ensure that the adverse housing decisions are based upon criminal activity, are supported. One of the best practices out there for the use of criminal records, many PHAs have adopted written admission policies that limit their criminal record screening to the use of conviction records. As a PHA, you want to stay protected. So now that you know you can terminate, let's talk about a well-written denial or termination letter. You've got your strong documentation. What are you going to do with it? First, you want to avoid legal issues, and you want to make sure your denial or termination notice is very well crafted and contains very specific information. The denial notification must be prompt. For a requirement, a well-crafted notice and adequate time, it must have a well-crafted notice and have adequate time. Best practice, termination letters give at least 30 days notice. And if your admin plan says 30 days notice, then remember, February has 28 or 29 days. You want to make sure that the regulatory citation is stated. You want to use plain English to describe the facts and how they are connected to the violation. Remember, you're spelling out the detail, letting the family know the facts. Most families are not proficient in legal terminology, and they need to understand what they're being terminated for. You want to include any attempted remedial actions before the denial of termination. If you sent 5 notices, list the dates those notices were sent. You want to gather reports, evidence, or other documents to include with the denial termination notice. And remember, criminal detail must be provided to the family. The family has the right to know what the crime was, and they might have more than one crime on one day. So when you're writing that notice, you should not say, on blank, you were involved in a crime. But a better way to say it would be, on blank, you were arrested for selling drugs in a school zone, and on blank, you were convicted of the crime. You want to include easy to understand instructions on how to request an informal review or hearing. You want to state the deadline for the family to request an informal review or hearing. The PHA has the latitude to establish reasonable timeframes for requesting the informal review or hearing. Where do you find it? In your admin plan. What do you do when a client requests an informal review or hearing? You want to make sure your practices are consistent with your admin plan. What should be included with the request? Should be, how are the requests accepted? Are they verbally? Are they in writing? Are they on a PHA form? Are they online? How quickly should the review or hearing be scheduled? You want to inform families of their right to inspect relevant documents. And we're going to discuss reasonable accommodations a little later, so I'm not going to get into that right now. There are several reasons why PHAs use denying and terminating assistance. Remember, a PHA is trying to keep out of the courts, so they're going to do what they can to manage program integrity and enforcement. Of course, you deny or terminate to enforce the regulations, but sometimes just to manage a program, the enforcement is used to resolve problems, such as a family not submitting documents timely so the PHA can do their recertification. Or maybe there appears to be an unauthorized household member and the PHA has exhausted resources to provide counsel to the family, so they use the termination as a deterrent. And of course, we can't forget, sometimes PHAs do make mistakes. We don't like to say it, but we do, and this gives them the opportunity to make those corrections. Now that we know the purpose of the review and hearings, what about our goals? Fair and equitable treatment, of course. You want to consistently apply the rules. You want to provide timely actions to requests for due process. You want to comply with all the aspects of the program rules and policies. Earlier I stated when sending notices there's a reason a person might not be eligible to dispute the denial or termination. Here are the reasons informal reviews are required and not required. They're required to sit with decisions concerning listing on a PHA's waiting list, voucher issuance, participation in the program, and any type of preference. But what about when they're not required? Unit size under PHA subsidy standards, the rejection of a unit that fail HQS or are not in accordance with family size, disapproval of an owner's lease, refusal to extend a voucher, general policy issues or class grievances, and discretionary administrative determinations by the PHA. Now that was the informal reviews. Informal hearings are a little bit different. Not a lot, but a little bit. I want to start by saying eligible immigration status is a denial for both applicants and participants. And whether you're an applicant or a participant, if you're being denied for eligible immigration status, you have the right to an informal hearing. When a PHA makes a determination of the ineligible immigration status, they must offer the opportunity within 30 days of the ineligibility determination. And the PHA must keep all denial or termination of assistant documents related to immigration status for a minimum of 5 years. When determining dollar amounts such as TTP or tenant rent or the utility allowance scheduled dues, those families have the right to have a hearing for those. If you're taking someone off the program through termination, or if you're determining a unit size they're eligible for, they can dispute that. And for the PHAs that have minimum rent, hardship exception denials have the right to have an informal hearing. But then when are the hearings not required? Again, when the PHA is rejecting a unit because it failed HQS, this could be due to family size. A PHA is not required to pass a unit that is not in compliance. The PHA methodology for utilities is not a reason for informal hearings. What about time limits on vouchers? You use it or you lose it. Items listed in your admin plan. Remember, public comment timeframes gave people chances to dispute what you were writing in your admin plan. When PHAs are not required to approve a unit, there might be a debarred owner or a non-compliant lease. And what rights a PHA is exercising against an owner is not between the PHA and the family. So there is no right to an informal hearing. Now that we know that you have what you have a right for and what you don't have a right for when you're denying and terminating, let's talk about those families' rights. A family may be represented. They can have legal representation at their own cost. They may have the opportunity to examine relevant documents before the review or hearing. If the family requests to review documents, any documents not made available upon the tenant may not be used during. They have the right to present evidence, and they have a right to a decision based solely and exclusively upon the facts presented at the hearing. Many PHAs are still gathering documentation when they terminate a family. Remember, these documents and they're not provided at the time they review the documents, they can't be used. So you want to make sure, the PHA wants to make sure that they have all the evidence available before the hearing. And the term documents includes records and regulations. Copies may be made at the requester's expense. Does your admin plan state the cost of copies? If not, you want to make sure that's in there. When terminating for criminal activity, you must provide the tenant with a copy of the exact reason of the criminal activity. We've talked about the tenant's rights. What about the PHA's rights? The PHA does have rights that they may exercise, and their hearing procedures may include that the PHA must be given the opportunity to examine at the PHA offices before the PHA hearing any family documents that are directly relevant to the hearing. The PHA must be allowed to copy any such documents at the PHA's expense. And if the family doesn't make the document available for examination upon request of the PHA, then the family may not rely on those documents at the hearing. So just like the PHA can't use documents at the hearing that they didn't let the tenant see if the tenant wanted to, the tenant can't provide them at the hearing, present them at the hearing if the PHA had made the request. Again, what does your admin say? I want to stress to you that the hearing officer cannot take anything into consideration after the fact. You want to make sure everything is presented at the hearing and it's complete. There's been so many times that I've sat in hearings where the staff have said, oh no, I don't have that, that's back at my desk. Or the hearing officer has asked questions and the staff's not able to answer it. If it's not presented at the hearing, the hearing officer cannot use it. So I keep talking about these hearing officers. Who are hearing officers? A hearing officer is a staff person from a department. It can be a staff person from the department, but a different functional team. They can be outside of the PHA. You have attorneys, other civic-minded people. You just need to make sure that when you have a hearing officer that they know the program regulations and the PHA policies. And then you can have panels of program participants, staff, impartial representatives from outside of the PHA. So as long as that person has not had anything to do with the actual termination or the reasons, then you can use that person as a hearing officer. What do you do when a client requests an informal review or hearing? You need to make sure your practices are consistent with approved administrative plan. How are they accepted? Are they verbally in writing, on a PHA form, online? What should be included with that request? How quickly should the review or hearing be scheduled? Some of the best practices requirements that it has to be in writing. They may be rescheduled. If you're late for a hearing more than 15 minutes, the hearing officer could uphold the PHA determination. If there's a no-show, you can terminate the hearing and uphold the PHA determination. And you have to know, are emergency situations going to be considered? When you're scheduling the hearing, you want to make sure that the notification includes the date and time and location of the hearing, the family's right to bring evidence, witnesses, legal or other representation. You need to make sure that they still know that they have the right to review any documents or evidence, and that the PHA will request copies of documents or evidence if we're going to. And if it's a special needs family, the family should be made aware that they should request a reasonable accommodation prior to that hearing. When you give that notice to the family, a PHA cannot terminate a family until after the family has completed the informal hearing process and the hearing officer has rendered a decision. You must continue to treat the family as if it's still in the program. This means if the family's been evicted and has requested a voucher, the PHA is not required to expedite issuing a voucher, but they cannot give the voucher to the next eligible family if the family has requested an informal hearing. When giving notice to a tenant, a PHA cannot terminate until the family has completed, oh, sorry, I already said that. The PHA must continue to treat families as if they're still in the program. You cannot delay the recertification. You cannot neglect obligations. You need to treat all of the standard processes. You can't rush or delay, or you could be called out for not providing equal level of treatment to all the families. And the family, of course, must be treated equally and fairly. If a family, you're not required to expedite issuing a voucher, or you're not required to expedite processing an RTA if you're in the termination, but you can't refuse to issue the voucher or start the process of the RTA. And this does include terminating a family that's been evicted and doesn't have a voucher. So when you're preparing a hearing packet, you want to make sure that you've reviewed all the documents, that you have an appropriate number of copies of documents, one for the file, one for the participant, one for the hearing officer. You want to make sure that you have the participant name and corresponding housing specialist name so that they know who to expect when the hearing, what to expect when the hearing happens. And the receptionist knows who's coming in for the hearing. And a written chronology is also very helpful. When conducting the hearing, you want to greet the families. You want to introduce. You want to record a record of all of the participants. You are not required to record. You want to have what your method of recording is. Is it written notes? Are you going to record the hearings? You want to make sure that the questions are being directed to the hearing officer, and you want to have an opportunity for each side to present the arguments. You want to ask questions and make sure that the hearing officer is keeping control of the hearing. So many times the person from the PHA that's representing the PHA wants to take control. It's the hearing officer who is in control of the hearing. You want to inform the participants when the decision is going to be made, and you want to make decisions based on the information that is presented. If a family wants a private hearing and they request it, you are required to give them a private hearing. You must issue a written notice promptly, and you want to make sure that you have a copy in the file. And again, there's no federal requirement to be allowed to record a hearing. So if somebody says they want to record it, if that's not your policy, you can say that there's no recordings. You want to document the hearing. Who attended? What was the reason for it? What occurred? You want to have the option to make sure that they know their option to have counsel at their own expense. You want to have the hearing officer's name, the date and time of hearing, the participant's current address, the participants who are in attendance. You want to make sure that you have the PHA representatives in attendance, and you must provide a private hearing if requested. What was the reason for the hearing? What's the decision being appealed? HUD regulations for termination. What are the pertinent dates? You want to discuss what occurred. What did the participants say? What did the PHA say? What documents were presented? What comments were made? And what was the decision? So when you're looking at the decisions must be issued in writing, and they must be prompt. They must cite the information from the documentation at the hearing. They should state who was in attendance. They should say what the termination reason was and what the regulatory citation was. And all of those items that I stated earlier that you want to have, that you're recording during the hearing, you're recording them so that you can have them as a part of the decision. So you'll have the name and address, the date of the date and time of the hearing, the final decision. You're going to give a brief statement of the reasons for the final decision. If it's a termination, you need to make sure you're citing the appropriate HUD regulations. You want to have the effective date of the termination, and any follow-up actions that the applicant or participant or PHA staff must take, and any applicable deadlines for those actions. You want to make sure that the hearing officer's signature is on the letter and any follow-up actions. Remember earlier when we talked about when a review or hearing was not required? Well, what about when a hearing when the PHA is not bound by the hearing officer's decision? If it's not required for unit size and the PHA subsidy, and the hearing officer were to say, well, I'm going to overturn the hearing, I'm going to overturn the PHA's decision, the hearing officer does not have that right. The hearing officer can't tell the housing authority they must approve an owner's lease. They can't tell a housing office that they must extend the voucher. And they have to make sure that when they're making their decision that it is in accordance with the rules and the regulations and not for a reason that was not allowed to have a hearing. Let's talk about some best practices. Some best practices that are followed by the PHAs include some PHAs include their entire informal review and informal hearing process as they are written in their admin plan with their denial letters and termination letters. Some PHAs have a form that they include with all letters so that the family has an easy way to request an informal review or hearing, and the PHA can give immediate attention when those requests come in. Sometimes when you get a whole lot of mail, the request for an informal review or hearing might get thrown into somebody's mailbox by mistake. If you're using an actual form, then when that form is seen, they instantly know, oh, that goes to the person that schedules informal reviews and informal hearings. They should have a time window that they must schedule the informal review or hearing. Best practices usually is within 10 days of the receipt of the request. That's scheduling it. That's not saying it must be conducted, but a lot of PHAs have the practice that they must be scheduled within 10 days. And that also cuts back on phone calls from tenants when they're trying to find out, did you get my request? When is it, when's my hearing going to be? You need to have a time window to conduct the reviews and hearings. Remember, a PHA can't remove from the waiting list or terminate from the program until after the informal review or hearing has been upheld. If you don't have a time frame set, then it could result in having to extend termination effective dates beyond what you had stated. It could affect your utilization because you can't issue the next voucher until that family has officially been terminated. It's important for the PHAs to review a percentage of the decisions to ensure compliance with HUD regulations. Sometimes PHAs get complacent with what the informal review or hearing officer is doing. So a PHA should set quality control standards, just like they do with new staff, especially when you have a new hearing officer. Maybe you do 100% review before decisions are sent out, and then you back it down after you're comfortable with the hearing officer and what the kinds of decisions the hearing officer is making. You need to remember, a housing authority cannot reject the hearing officer's decision, but you can have a conversation with the hearing officer about the reason why they made the decision. The hearing officer is not your rubber stamp. You need to make sure why the decision was made. All right, the big one, fair housing. Fair housing is the law, and you must make sure that protected classes are recognized. Quad-L is going to have a training session in March that's going to go into a lot about fair housing, so I'm just touching on it today. And I encourage everyone to sign up for the training that's in March so that you can get a little bit more proficient in what the real rules are. You have the federal protected classes, which are race, color, religion, sex, national origins, age, disability, and familial status. If you don't know those, memorize that list. And there are several laws that address fair housing and protected classes. All families are covered under the laws, whether they're on the housing program or not. If you're not familiar with the acts, this webinar is going to be available on our webpage next week, so you can copy them down, or you can get a copy of this PowerPoint when it's posted. Again, I encourage anyone that's listening today to participate in the webinar on fair housing. Earlier I said we were going to get back to reasonable accommodation. Remember that reasonable accommodations must be made for individuals with disabilities. This includes accommodations for informal reviews and hearings. A reasonable accommodation could include modifying your policies, procedures, and practices when they are needed to make it possible for a person to participate in the program. Sometimes allowing a tenant to make a physical modification to a unit and common areas to accommodate mobility impairment. But what kind of things can you do in your PHA that could be accommodating? Well, somebody who is blind, you could have Braille. You could have somebody that needs to have their print enlarged. You could have it magnified for them so that they can read it. You can print it out in larger font. For somebody that is hearing impaired, you could get an interpreter in for them. And don't forget LEP. You also have reasonable accommodations for LEP. A PHA should always consider mitigating circumstances that could have prevented a family from complying with the rules. Remember, as a protected class, reasonable accommodation should be made when requested. It's not your job as a PHA to try to think if somebody might need a reasonable accommodation. It's the person's responsibility to let you know that they need a reasonable accommodation and what that is. It's not your job as a PHA to say, well, tell me what is your disability. It's your job to say, what is it that you need from us to assist you to be able to work with our agency? If your denial and termination letters are written well, then they're going to include what needs to occur for a person to request a reasonable accommodation. And remember earlier when we were talking about what you should have on a denial or termination letter, you do want to include what is, who is it that they contact, what is it that they need to do? Do you have a special form that they need to fill out to say they need to have someone special? And it also needs to be requested in advance. You're not expected to pull out that magic wand and have that sign language interpreter there the day a family member shows up for an informal review or hearing and doesn't have an interpreter. I'm going to open up the lines for questions. I hope that this was a helpful seminar for you today. And if you want to just put your hand up if you have a question, I'll gladly answer it. No questions? All right, well, thank you for attending today.